The topic for today is 10 steps to take if you're injured at work. My name is Ty Wilson, and I am a Georgia workers' compensation attorney practicing law in the state of Georgia. So let's get into it. All right. So first of all, you want to have a brief idea of what's going to happen here in this slideshow. When you get an injury on the job, it is unexpected. Nobody wakes up in the morning and says, "Hey, I'm going to head to work and probably have an injury today." It's the last thought in your mind. And so when it happens fast and it happens quick. And so this is something to prepare you and let you know, okay, something's happened. Now, what do I do as an injured worker? All right, so you need to know what you're entitled to, and you need to know what benefits you can and cannot get. Certainly, if you need help, you need to reach out to a Georgia workers' compensation attorney, whether it's my office or another office. You want to seek help whenever you need it. You don't want to wait an extended period of time because that can affect your claim, especially early on, right after you've been injured. Now, remember, this is just a warning for everyone who has been injured on the job. If you are getting health insurance through your employer and have an injury that takes you out of work for an extended period of time, this doesn't apply usually if it's just a simple injury and you're back to work very quickly. But if you are taken out of work for an extended period of time, what pays your health insurance premiums is your paycheck. Well, if you start getting income benefits through workers' compensation, you will no longer get your paycheck from your employer. You will get income benefits from the workers' compensation insurance carrier. And they are two different companies usually. And as a result of that, there's nothing or no one paying premiums to your health insurance. And so if you know that's the case, you do want to proactively reach out to your employer and see if you can keep paying those benefits with the hope of obviously returning back to work. If it's a very serious injury, that may not happen, and they may push you out on what is called COBRA sooner than you want. But you need to know about that to protect your family members who may also depend upon that health insurance. All right, so let's get into this. All right, what is the first thing you do? Well, you want to immediately report the injury to a supervisor or boss or the owner even. You need to let them know how you were hurt. You need to let them know what body parts, head to toe, hurt, feel funny, feel different as a result of the injury. And then you want to tell them what you were doing while you were hurt. And then lastly, after reporting the injury, you want to do this at the same time as you want to ask for medical care. You want to say, I need to get some medical attention for these injuries. Number two, document everything. What do we mean by that? Well, you want to keep paperwork. You want to create a file. A lot of times workers are not, they don't want to do paperwork. They don't want to be around the department that does paperwork, but you need to do this. This is going to be in your best interest. And certainly if you hire an attorney, you want to have this paperwork for them, and that will help bring them up to speed. It'll be less of them having to hunt and try to gather documentation that may be out there, but you may not have a copy of it. So you want to keep a file in your home for yourself of your work status reports and so forth. So one of the first things in documenting is you want to notify the employer, and you can do that verbally, but you don't want to leave it just verbally. You also want to make sure you give them something in writing. If you need help with a very general, generic letter, notice of injury letter, we will provide you one. If you want to contact our office, we'll do that free of charge with no obligation. The important thing is that you give them something in writing so that they can't say you never reported the injury. If you do it just verbally and you don't get contacted from the insurance, the workers' compensation insurance carrier, you're not getting medical care, no one's calling you. When you contact the employer, they act like they don't know what's going on, or worse, they're not returning your calls. That's not a good sign. So you want to make sure that you do your part, give them a copy. You want to keep a copy of your notice saying, I was injured on the job at this day. You know the time, fine. That's not so critical. It's at this day, what you were doing and what body parts were injured. You put that in writing, very simple, give that to them. We recommend you fax it to them. If you fax it to them, you have confirmation from that fax confirmation that they received it. If you just email it to them, you don't know, it could have gone to their spam. They may not have received it. So you want to make sure that they receive it. If you hand deliver it, that's fine. You can put delivered by hand at the bottom of it after you delivered it, and who you handed it to. That's critical. You want to keep your paperwork also along the document everything. You want to keep your paperwork, like I said earlier, from all the medical visits. Well, the idea is if you've been hurt, you need medical care, get to the doctor, and the doctor is going to make what's called a work status report. After every visit, you should get a physical piece of paper that says you are either out of work completely, you are released to full duty, back to normal, great, or that you are on limited, light, or modified duty. And then it should have restrictions, no bending, no stooping, no using one arm. Depends on your injury, obviously. But the doctor should make that. If the doctor says you're out of work completely, that's something that you'll want to keep a copy of, but you also want to send a copy of it to either the adjuster or if you have an attorney, your attorney. Your attorney will send it to the adjuster, and then they will work to get you income benefits as quickly as possible. You also want to share it with your employer, and that means a good idea would be also to fax that to your employer. If you fax that to your employer, you got confirmation that they received that you were out of work. Also, if the work status is full duty, well, you can show up at work and hand it to your employer, and it's going to go in a file, and back to work you go. If it's light duty, the employer needs to make a decision. They have a decision to make whenever you're light duty. Depending upon your restrictions, can they bring you back to work? If they can, then they may say, come back to work. You have an attorney. That is a very critical time. I would speak to them prior to returning back to work. If you've been taken out of work or were at light duty and they sent you home and you started receiving weekly checks from workers' comp, before you go back to work, you want to make sure through legal counsel that you're doing the right thing. That is something that could have a very detrimental or bad effect on your case depending upon the circumstances. So it's very fact specific. Always recommended you speak with the Georgia workers' compensation attorney to find out what is in your interest and your family's interest. All right, moving on. Seek medical care and attention. As I said, you're going to give notice to your employer that you've been injured on the job, how you got injured, what body parts are hurt, and they should have something called a posted panel of physicians or a list of doctors that you can go to. If they do, there are legal questions as if the panel or posted panel of physicians is legally valid. That's something that you'll want to speak with an attorney about. Doesn't necessarily mean you have to retain an attorney, but you want to find out, is this panel valid? If it is, you need to stay on it and have to go to those doctors. You may have the opportunity to go to any doctor you want, and that is huge when it comes to a workers' compensation claim in the state of Georgia, I can assure you. So that's a very important part. Again, feel free to reach out. We look at panels. We talk to people about panels all the time. After you notify your employer, as stated earlier, when you give them notice, you want to ask for that medical care, okay? They have that list of doctors, great. Get a copy of it so that you can share it, speak with others about it. If they do not have a posted panel of physicians, you may want to speak with a Georgia workers' compensation attorney who can offer you a list of doctors that handle workers' compensation claims in your area. That can help speed things along for you. Now, it's important for you that you get to a doctor quickly. A doctor, depending upon who it is, if it's a clinic, that is the fastest way to get to a doctor without question, faster than any of the other ones. They can usually see you the next day or sometimes the same day. That's great. But then they could be established as what's called your authorized treating physician, meaning they are your main doctor. Typically speaking, a clinic will not take you out of work for more than 2 or 3 days. And they're going to push you back with restrictions. And that's fine as long as you don't have a very serious injury. If you have a very serious injury, you may want to wait to get to a specialist, whether it be an orthopedic, a neurologist, or a neurosurgeon. That is something that you may want to speak with the Georgia workers' compensation attorney, as that could be a very critical decision at that point in time. Knowing your rights. You want to know what your rights are. Well, if you're an employee and not an independent contractor, and your employer has 3 or more employees, they are required under the Workers' Compensation Act in Georgia to maintain workers' compensation insurance coverage, okay? If you're injured as an employee and you are not horseplaying, you are not under the influence of drugs or alcohol, then typically speaking, you have a workers' compensation claim. There are many exceptions, but that is kind of a general blanket statement. So what does that entitle you to? Once you have a workers' compensation claim, then you're entitled to medical care as it relates to your work injuries. If you have a workers' compensation claim, what does that entitle you to? Well, typically speaking, be for medical care as it relates to your injuries. That's again, head to toe, everything that hurts or feels funny or feels different. All right. At first, that's all you're entitled to unless it's a very serious injury. Then after 7 days, you could be entitled to what is called income benefits. And that depends on if you're able to work partially or if you're out of work completely. If you're out of work completely, it's called temporary total disability. If you're partially disabled, where you've given restrictions and your employer can accommodate you, you may or may not be qualified for temporary partial disability. Depends on your pay. It's very complicated, very fact specific again. So you want to reach out to a Georgia workers' compensation attorney. All right. Notify your employer in writing. We covered a little bit of this before, but it is important that you provide your employer notice of your injury. The deadline currently is 30 days. Now, the one way to guarantee that you've provided them notice is to provide it in writing. Again, we provide a notice of injury letter free of charge. We'll send it to you via email. It will not have our letterhead on it or anything like that, but you can certainly use that to notify your employer if you don't know what to put in a notice of injury letter. Let us know if that's something you need. However, once you get it to them, you want to fax it to them so you can get a fax confirmation so that you know that they've received it, or you want to hand deliver it, and then you want to keep a copy and write on the back of it, hand delivered such and such date to whoever you hand delivered it to. That is your proof that you provided notice. Do all claims need this? No, but some of them do. And it just depends on if that employer or that insurance company, more importantly, is going to fight the fact that notice was not given for a particular injury. And you want to cover your bases. Again, you want to do this quickly. You want to do this within 30 days of when you got injured. Now, 30 days of when you got injured, when you're lifting and you feel a pop, okay, that's pretty straightforward. But what about an injury where it's repetitive motion? You've got carpal tunnel, where you're doing the same motion over and over again, and all of a sudden you feel pain, and then now you can't work or you need to get to a doctor. That would be on the date that you feel like you needed to get to the doctor. You could no longer work. You tried and tried and tried, and then it became too painful. So that would be the date from the 30 days running. So just keep that in mind. Always recommended you speak with a Georgia workers' compensation lawyer, as that could change as far as a rule or any type of deadline. Understanding your benefits. As we said earlier in this video, medical care is established once you establish that you've been injured on the job, doing the job you were hired to do. You're an employee, not a contractor. You weren't horseplaying. You weren't under the influence of alcohol or drugs. You typically have a medical only claim providing you medical care for you in the body parts that were injured. Now, from there, when do you get income benefits? If you're taken out of work completely for more than 7 days, after the first 7 days, you don't get paid. After 7 days, if you are out of work for 21 days or 3 weeks, then you will be paid for the first 7 days. Most injuries do not go 21 days. And so that's the idea of why they created the law that way. So you will ultimately be paid for the first 7 days if you're out of work for more than 3 weeks. All right. Mileage. Mileage is a biggie. Sometimes the adjusters will let you know about mileage. Sometimes they forget. They got a lot of files on their plate. So mileage currently under Georgia law is 45 cents a mile. That's if you're driving your vehicle. If transportation is provided by workers' compensation, you're not entitled to mileage. But if you're driving your vehicle, it would be from your home or your work or wherever you go to drive to the doctor's office, and from the doctor's office back to your work or your home or what have you. So it's round trip. Same thing with physical therapy. Same thing with any type of MRI films. If you're going to get an MRI, mileage there would be reimbursable. Mileage to the pharmacy and back would also be reimbursable. You want to keep a spreadsheet. While the adjusters may be approving doctor's visits and may know where you're at, they're not keeping your mileage for you. And so what's critical is that you keep a mileage log. We have mileage logs. If you need one for your records, we'll be happy to email you one, and you can print it out as many times as you want. But you want to fill out the address you were at, the address you went to, why you went, doctor's appointment, MRI, pharmacy, physical therapy, what have you, and the amount of mileage. And what we do as a law office is we back it up with a Google map showing the exact breakdown of the mileage. We don't give them the long version. It's the most direct version that they're going to pay for. And we don't get a lot of pushback on mileage as a result of that. Prescriptions. Prescriptions are also reimbursable. A lot of times the workers' compensation insurance carrier will provide you a prescription card or will mail you your prescriptions, but not in all cases. And so in some cases, you have to go up to your pharmacy and obtain the prescription. You may have to pay out of pocket. So you want to keep all the paperwork. You know, they give you a lot of paperwork, staple it to the bag and all that good stuff. You want to keep all of that because that shows what doctor prescribed it and other important factors with that prescription itself. And that is the quickest way to get those prescriptions reimbursed. Same thing if you have to have any type of medical equipment, such as a back brace, a cane, a walker, anything along those lines, a wheelchair. Keep the paperwork related to that. Keep it in your file. If you have an attorney, give it to them. They will seek to get it reimbursed and get you paid back as quickly as possible if it hasn't been paid prior to you receiving it. Follow the doctor's orders. Well, this is pretty straightforward. If the doctor has you out of work, you need to be out of work. If you're not out of work and the insurance company hires an investigator to follow you around and catches you working, I can tell you this, your workers' compensation claim is in jeopardy of ending very quickly. And so you want to follow what the doctor's orders are. When the doctor says no work, that's pretty straightforward. When the doctor says full duty, pretty straightforward. Where it gets funny is when the doctor says limited work. You can only lift 20 pounds, not your normal weight. And so in those cases, you still want to follow the doctor's orders. The employer may bring you back to work. If they do, you want to carry your restrictions with you because the employer, in all reality, is not going to remember your restrictions. And when they say, hey, can you go over there and help so-and-so lift those 50-pound bags of concrete or whatever, you can pull out your restrictions and say, look, I'm sorry, boss, but I've got these medical restrictions. I can't lift more than 20 pounds. They may be frustrated with you, and understandably so. They need to do a job. However, that is your ability to show them where your restrictions are, and then they have a decision to make. Do they keep you there and they just put you in another role where you won't be lifting anything more than 20 pounds in that example, or do they send you home? And if they send you home, remember, your claim's not over because they sent you home. They may bring you back to work at some point later. If they terminate you, your claim is not over as far as your work injury is concerned. If the claim has already started, then that is the important part. You do need to speak with a Georgia workers' compensation attorney as your benefits may be affected in certain ways. So you want to speak with them to see what are the next steps you need to do to move your claim forward and to get back to where you can go back to work, especially if you need to get a new job. All right, I think we've covered everything here. Keep track of your expenses. This is something very similar to what we talked about with documenting the paperwork. The adjuster, again, does not know your mileage. The adjuster knows you're going to appointments, but the adjuster has a tremendous amount of paperwork to keep up with and a tremendous amount of files like yours to keep up with. And it will be difficult to get them on the phone, but that's not the point of this. The point of this is they're not going to fill out your mileage checks for you. And so what's critical is that you do that and that you keep a log. You can do it on an app, but you want to put it in a log to turn over to the adjuster to get reimbursed at 45 cents a mile. Once you do that, the main thing you want to probably keep in mind here is that every 2 to 3 months, you want to turn in your mileage. If you don't, you're recreating mileage from further and further back. You can do that by getting invoices from the doctor's offices showing when your appointments were, if you didn't keep them on your calendar. However, that is hard to do. So you want to kind of keep it as you go along and then turn it in every 2 to 3 months. The most important thing to know as we stand today in 2024 is that if you don't turn your mileage in within the year, then the insurance company does not have to pay you. The statute of limitations will run on that within a year. The same thing can be said for prescription reimbursements or any type of expense that can be reimbursed through medical equipment or what have you. If you don't turn it in within a year, then the statute will run and they do not have to pay you back. And then you just basically ate the cost of something that should have been reimbursed. So you don't want to let that happen if you can help it. Every bit of benefits allowed under the Workers' Compensation Act is helpful. Lastly, contact a lawyer if you need help. Our office offers what we call a free strategy session. Ask you a few questions, try to find out where you are in your claim and try to give you some guidance on, okay, this is what you need to look for, or this is what you need to do to get this done. Have you thought about this? This is something we can do. Kind of talk strategy and talk about what can be done with your claim to try to get it either resolved or get it moving in the right direction. What can you do as far as changing physicians, stuff like that? There's many, many topics, and too many to cover in this video. But the important thing is we offer that service free of charge. We just ask you some information. We'll get on the phone and we'll have a conversation, talk to you about what we think should happen based on where you're at in your claim, warn you about some things to look out for. And then from there, we part ways. If you wish to retain our services, great. If not, we understand. We talk to a lot of people, and most of them we do not represent. But if you do need an attorney, don't let too much time go by. That can affect a claim, and you don't want your claim to be affected by just not doing anything, because by not doing anything, you are making a decision, and that decision is usually one that will affect you. So keep that in mind. All right. In conclusion, let's look back at this. So always report your injury to your supervisor. Document everything. Request medical care when you get injured and give them notice. And when I mean them, I mean the employer, and seek medical attention and make sure you follow the directions. Know what you're entitled to as an injured worker. And that would mean medical benefits or medical care as it relates to your injuries, and then possibly weekly checks, depending upon if you're taken out of work or not. Notify your employer in writing just to cover your bases. It's always a good idea. Understand what benefits you may receive, and certainly reach out to a Georgia workers' compensation attorney if you have questions about how they calculate your income benefits. We're going to be doing that on another video, so you may want to check back here. Follow the doctor's orders. If you're caught not following them, doctor will release you. The insurance company will get an investigator, typically to follow you, record you on video, show it to the doctor, say, doctor, do you still think they're out of work completely? The doctors get upset when you don't follow what they're trying to do to help you. And they typically will say, well, I'm going to release them to full duty. And now you're kind of in a difficult position. Keep track of your mileage and keep track of your out of pocket expenses, such as pharmacy, prescription, or any type of medical equipment. And if you ever have any questions, always reach out to Georgia Workers' Compensation Attorney. The consultations are free. You have nothing to lose but the time, and it should provide you information that will be helpful to you, whether you retain that attorney or not. We hope this information has been helpful, and we will see you on the next video.
If you or a loved one has been injured on the job and have questions about what is going on with your claim, feel free to give us a call or reach out. We'll be happy to answer any question we can to help you move along with the claim. Thank you.